I'm attorney Ashley, and I'm an immigration attorney. My law firm is located in Bend, Oregon and Carlsbad, California, but we service clients all over the United States. In this video, I'm going to talk about different ways to qualify for a green card without marriage. Now, there's many different ways that somebody can qualify for a green card without having to be married to a U.S. citizen or even a lawful permanent resident. So to start off with, we're going to talk about other family-based options for qualifying for a green card. And then we're going to talk about some humanitarian options that can allow somebody to receive a green card. So if you are related to a U.S. citizen, for example, if you are the unmarried adult child of a U.S. citizen, or you are the married adult child of a U.S. citizen, you can qualify to receive a green card. Additionally, if you are the sibling of a U.S. citizen, your U.S. citizen sibling can petition for you as well. It's important to keep in mind that the process is slightly different if you are applying for a green card under either of these categories. Additionally, if you are the unmarried adult child of a lawful permanent resident, you can also qualify for a green card, as well as if you are the minor child of a lawful permanent resident. That's to say, if you are under the age of 21 and you are unmarried and your parent is a lawful permanent resident, you can also qualify for a green card through them. So as you can see, all of these categories do not require that you be married to a U.S. citizen or a lawful permanent resident. Depending on the situation, you can qualify in either of these categories through adjustment of status in the United States or through consular processing, which means that you have to leave the United States, or maybe you are always outside of the United States when you are applying for your green card, and you have to attend an interview at a U.S. consulate or embassy in your country in order to receive your immigrant visa to then enter the United States as a green card holder. The rules are very different if you are going to be applying for adjustment of status. In many cases, doing adjustment of status in any of the categories I just mentioned, so I will repeat those again. They are: if you are the adult unmarried child of a U.S. citizen, if you are the married adult child of a U.S. citizen, you're the sibling of a U.S. citizen, or you are the unmarried adult child of a lawful permanent resident, or you are the minor child of a lawful permanent resident. In any of those categories, typically it's going to be difficult to do an adjustment of status, and you're going to be required to do consular processing. Other ways that somebody can file for a green card that do not depend on being married to a U.S. citizen or a lawful permanent resident is through a humanitarian case. These cases are a U visa or a T visa. So the U visa is for immigrants who are victims of certain qualifying crimes in the United States, who have helped in their investigation and who have suffered substantial harm as a result of being a victim of that crime. While the U visa doesn't initially result in a green card, it creates a pathway to a green card, which means that once you receive your U visa, after you've had it for 3 years, you can apply for your green card. The T visa is for people who are victims of different kinds of human trafficking. So that can be most often labor trafficking. It can also be in the context of a relationship that perhaps you were in. Doesn't require that you be married, but if you experienced having to be forced to work in your home, having to do certain things for your partner, sometimes that can qualify for a T visa as well. Sex trafficking qualifies for a T visa, but again, the most common scenario that I see in my practice is based on labor trafficking, and that's when an immigrant is being exploited at a job because they don't have papers. So that can look like having to work a lot of hours without being paid properly, having to work overtime without being paid double or whatever the requirement is in their particular state. It can look like having a boss who is intimidating, who is threatening the immigrant that if they don't continue working in these unlawful conditions, then they can contact immigration and have them deported. Things like that. Those are just some common examples that can possibly qualify somebody for a T visa. So similar to the U visa, once somebody receives a T visa after having their T visa for 3 years, and in some cases sooner, they can qualify for a green card as well. And so as you can see, the U visa and the T visa are two other options in immigration that would allow somebody to eventually receive a green card, and it does not require them to be married to a US citizen or a lawful permanent resident. Now, the filing fees for each of these case types is different, and it will depend also if you are doing the case from inside the United States or if you're doing the case from abroad. So if you have any questions about the specifics around any of these options that I've just discussed, please feel free to reach out. Our phone numbers are 760-812-3778 or 541-275-0688. And you can also like, comment, and subscribe to this channel. Thank you.